And are you Mr. Anders?
Yes, Your Honor.
Counsel, you received all discovery. Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Anders, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I believe we're waiving the punishment enhancing, but otherwise proceeding this.
Any objections?
No objection.
This is an opposed offer. Okay. All right, Mr. Anders, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with unlawful possession of a firearm by a felon. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Anders, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison, $2,000 fine. State is opposed to your applications. Did you understand that to be the plea?
I believe so, Your Honor.
All right, so you can apply for probation. They're going to tell me that they don't want you to have probation. And I could deny your application and sentence you up to 6 years in the prison. Did you understand that?
Yes, Your Honor.
All right, state defense, is that the plea?
Yes.
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Thank you.
State any evidence.
Judge, we have to say exhibit number 1 and all attachments.
No objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to jury trial, the right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent. Did you understand the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I did, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you would like to come back sooner.
I'm ready today.
Okay. All right, the court then will hear argument.
What was there for both, Judge?
Judge, I understand it's a felon in possession of a firearm, and I hope the court read that police report, but I hope she read it very carefully. Okay. The simple fact of the matter is he pled guilty because he is guilty. That's what he said. He should have never had a gun. His son's birthday, 18 years old, went to his stepfather's house. Stepfather, for some reason, doesn't like him, but he went over to the house just to say happy birthday to his son. Because the stepfather doesn't like him, calls the police and tells the story about how he is threatening him and pointing a gun at him, which never happened. And what ended up happening, the police show up, sees him out there. Oh, we did there, and there's a gun found in the vehicle. Then the father-in-law turns around and tells the police, oh yeah, he never threatened me and he never brandished a gun. The reason I tell that story, Judge, is this: he should have never had a firearm because he is a felon. This isn't the kind of case that we give up to 6 years. He's not brandishing it. He wasn't threatening anybody. It was just about him going to see his son on his birthday. Should have never had the gun, and his stepfather just not liking him, trying to get him in trouble. So we're asking this court basically to grant this application. If not, based on the facts of this case, Judge, I would hope that the court would go on the lower end of that sentence.
Hey,
Judge, our argument is that Mr. Andrews was sentenced to 2 years TDC back in 2019. He was then sentenced to 4 years TDC back in 2024, and he was found with an unholstered firearm in his waistband. Judge, we'd argue that Mr. Andrews is not complying with the law. He's already had multiple penitentiary trips, and we think 6 years is appropriate.
all right, I'm gonna give you a choice. These are your choices. You only have these two choices. There are no other choices.
Okay.
One, I'll deny the motion, sentence you to 2 years in the prison. Or two, I'll grant your application for deferred adjudication. However, if you're revoked on the deferred adjudication by some other judge, because I will not be here, you're looking at potentially 10 years in the prison.
You'll pick what?
The deferred adjudication.
Can I have one quick second?
Sure. Hello, and for the state. And are you Mr. Terry?
Yes, I am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Ronald Terry who was placed on community supervision in 2020 CR 10452 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on January 26, 2021 for a term of 4 years? Is that you?
Yes.
All right, state.
Violated condition number 5 in Bear County, Texas, the defendant Ronald Patronus Terry did in there fail to report to the supervision officer as directed for the months of October, November 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State will waive the remaining allegation.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
No, Judge, there is not, but state would be asking you to grant state's motion and sentence to 2 years in the prison. This is based upon the defendant's absconder since October of 2020.
All right, how old are you?
71.
All right, thank you. Here's the thing, you're 71. If you don't stop using drugs, you know what's gonna end up happening to you?
Yes,
Yeah, or either in prison. Do you have family here?
I do.
All right, you better make changes. Counsel, let him know where he can go to get treatment and get help.
Your Honor, may I speak on his behalf, please?
No. Court is finding 5 true. Motion is denied.
Thank you, Your Honor.
Thank you.
Tell the judge, thank you.
You're welcome.
Your Honor, he had a really good story. He really did.
Let me hear the story.
Your Honor, he was reporting.
I know it's
He
true.
did pay and he did do his community service, but Social Security found, SSI found that he was unable to live at home. He's in a full, Hunter Pond, for the other, he was unable to take care of himself. That's why he stopped reporting. He hasn't picked up anything new. He lost his wallet and went to go renew his license and realized he had a
You
warrant.
should have came in to see me.
Then he would have
We
missed me.
Yeah, then he would have missed you. So you had a very good attorney. So do you have a place to stay now?
Yes, on
He does. He does.
All right. If you're ever looking for a place, they have Twin Town, Tiny Village, and you meet the age category for that. Let me make sure I'm giving you the right name. Yeah, it's Town Twin Village. And it is such a nice place. Have you ever been?
I haven't.
You should go there. It's located on Dietrich Road. You're with Shriners and everything, right? You should have them do a tour for Shriners so they can see what they do out there. It is a great place. They allow you to do laundry. They allow you to take showers. They provide meals for you. They even have a movie night. I didn't get a chance to stay for their movie night. They have therapists on site and they have these tiny homes there. And they are absolutely gorgeous. And you get to, once you're accepted, you get to design your home. Like, do you want it with an enclosed porch, which is what I would do, the enclosed front porch. And it comes fully furnished. So bed, you are just ready to live once you get in there. You don't have to buy silverware or any of that. You don't have to, they give you sheets, they give you towels, everything that you need to move in. And then what they charge for it is just a percentage of whatever your Social Security is. So it's a great place. And then if you receive zero money, you know how much they charge you?
Okay.
All right. But take care of yourself. They should be releasing you sometime at 1 a.m. or midnight. Do you have someone to pick you up?
Yes.
Okay.
Here's one out in San Antonio. We'll get hold of them.
All right. Thank you.
Thank you, Judge.
Yeah, I had already made my mind.
No, but you can't stop an attorney.
Yeah, I know.
Waited all day. Thank you, Judge.
Thank you.
Hello.
Hello, how you doing?
Oh, I'm doing great. How are you doing?
Wonderful.
I'm fine. Let me see. All right. So where are we on discovery?
Judge, I have the discovery that the state has tendered. I've downloaded it. I've been talking to the state about resolving this case. It's my understanding that Brandon's going to review some dash cam and body cam videos,
Okay.
and then he'll make an offer at the next setting.
All right. 30 days?
Yes, Your Honor.
All right, Norma, I need a 30-day reset. Thank you, Brandon.
Of course.
Yeah, June 22nd.
All right, is that a good time?
It is, Your Honor.
Same thing.
I don't know if I guess it requires. Let me get you something in writing.
Appreciate it.
Okay, close this.
At this point, he wants time to think about the offer. So if you have to set it for trial, that's fine, Judge.
All right, and that person in the back with you, do you know them?
No, Your Honor, he was just talking to me. I got distracted. I apologize.
Oh, no. I was gonna say if that was your brother, I'd put you on the same date so y'all can drive together, but since it is not. Norma, recall this. How old are you?
I'm 25.
All right, Norma, recall this for a plea deadline date. I'll give you your final plea deadline date in 3 weeks.
3 weeks. Awesome. Thank you, Your Honor.
Oh, no problem.
Will be June 11th.
June 11th, good.
You guys sort of look alike.
Thank you, Judge. Have a wonderful day.
All right, you too. Thank you.
God bless you.
Oh, God bless you too. I'm loving the God bless. Right, currently they're in the middle of graduation, so they can't be here. So we can recall this to have them to be here to give me insight, or either we can go forward.
I think that he would rather recall this and get some insight into this.
Okay,
Yes.
all right. So we'll recall it. And I'll keep this with me. All right. But Sean, you think they'll be able to be here in 2 weeks?
Yes, give that much. Yeah.
All right, Norma, if you can recall this in 2 weeks, it's Camacho.
June 4th.
All right, we're gonna come back, June 4th. I'm not gonna be here. Isn't that the first week in June?
Yes.
If you can put it that second week, unless you want another judge to hear it.
No, that's good.
Okay.
We have to wait unless you want to go forward today, but your options are limited.
All right, so we'll be back on June 8th.
Thank you.
Thank you.
God bless.
God bless you too.
You take a seat.
Just 1 second.
No. So next.
Norma, we need to do the one with Charles Gull. We'll do your case. Is it still contested?
We're still talking about it.
All right, so we need to do the contested because there are people from, what is the person's name?
Natalie Lodge.
Yeah, there's somebody from probation on Zoom. Announce for the record.
Lauren Espinosa for the state.
Charles Gold from Mr. Carvajal.
And are you Mr. Carvajal?
Yes, ma'am.
Jury review the first amended motion to enter adjudication of guilty and revoke community supervision and the motion to enter adjudication of guilt and revoke community supervision with your attorney. Did you understand it?
Yes.
Yes, Your Honor.
All right, off the record for a moment. Oh, that's how you spell his last name. Sometimes my pronunciation isn't what it should be. Thank you. Are you the same Josue Carvajal who was placed on deferred adjudication in 2022 CR 5498W for the office of unauthorized use of a vehicle on June 7, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
On state's first amended motion to enter adjudication of guilt, violated condition number 2 on or about the 27th day of March 2025 in Bear County, Texas, the defendant Josue Carvajal did then and there fail to drug testing as directed by the court officer, supervision officer, or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Violated condition number 2 on or about the 27th day of June 2025 in Bear County, Texas, the defendant Josue Carvajal did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Okay.
Violated.
Just 1 second, off the record for a moment. So, Deputy, could you move them down to the other end? All right, you may continue.
Violated condition number 2 on or about the 15th day of August 2025 in Bear County, Texas, the defendant Josue Carvajal did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
It's true.
Violating condition number 4 in Bear County, Texas, the defendant Josue Carvajal did then and there fail to report to the supervision officer as directed for the months of September and October 2025 in violation of condition number 4.
How do you plead to that?
True.
Finally, violated condition number 29 in Bear County, Texas, the defendant Josue Carvajal did then and there failed to submit to drug testing as directed by the court officer, supervision officer for the months of September and October 2025 in violation of number 29.
True.
State will waive the remaining.
Any objection to the
No.
waivers? Did you understand by pleading true to those violations, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 2, 2, 2, 4, and 29?
Yes, ma'am.
Court will find violations 2, 2, 2, 4, and 29 true. Is there a proposed agreement?
There's not, Judge. The state is asking that you grant its motion, enter an adjudication of guilt and sentence to 2 years in the prison. Judge, this is Mr. Carvajal's 4th MTR. If there's anything that's shown based upon the record in the court's file, it's that we find ourselves in a situation where Mr. Carvajal is either pleading true to a condition 4 or 2. The court then allows alter an amendment to his conditions and we're back in the same position. I don't believe Mr. Carvajal wants to be on probation any longer based on his lack of complying with the conditions, probably despite what he's going to tell the court today. But I don't think he's a good candidate. He's shown he's not a good candidate, and I think it's time that he's revoked.
All right, defense, what are you requesting?
Judge, he pled true and is accepting responsibility. This is not new violence, new victims, or escalating. He's struggling with instability and structure, I think. Is whether those violations is sufficient, is necessary. What can we do to address those? He failed probation, he stopped engaging, he has accepted responsibility, and the court has extended opportunities. But I think we got to look at, there's been no violence, no weapons, there's no more victims, there's no assaultive conduct, there's no dealing or trafficking, there's no other criminal behavior besides just not showing up. The he does have multiple negative drug tests. He completed the Bear County outpatient program, additional outpatient participation from 2024 to 25. I think he's done over half of the community service hours. He has some prior employment compliance and, like I said, some community service. I think that what we have here is a cognitive issue. I think he would like to be extended and do some sort of inpatient for the cognitive. I think that would be graduated response through the MTRs. I think that'd be appropriate. It's not so much that he was using, but he's just missing. So again, I think it's more cognitive than anything. I think he needs some sort of stability. He needs structure and something to help him with his fear and avoidance with probation. I don't think he's minimized anything. And I think the maximum sentence would be reserved for somebody who, I don't know, has done something way worse than what's going on here. So if you do decide to revoke, we would ask for 6 months, Judge. But we would ask that you continue and that he can come out a better person. He's still young, and I think we can still save him. Do you want to say anything to the court?
Judge, I know I have been.
Oh, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record. Why don't you report?
I just have been, I've been honestly, unresponsible over my actions.
Here's the thing, and so I want you to tell me whatever you want to tell me, but I wanted you to know where I'm coming from so you can understand the answers that I'm looking for from you. You've been in this court previously before. It's always a violation of condition number 4 or condition number 2. And then I will ask you, what do you need from the court so that you will complete this probation? And whatever you need, I always give it to you. So I've given you the MRT. Each time you come in, I try to help you with something. And we're back here for the same thing. So you can address those issues because that's the issue. You keep coming back for the same thing.
The MRT, I did, the class that I was actually attending, it was.
That's not the question. The question is, why aren't you reporting and why aren't you giving drug tests? That was the question. So she wants to know the answer to that. Why aren't you doing that? Or is it how old are you?
22.
And so you're old enough to get to court. Why haven't you grown up and done that? Why aren't you going?
Then I'm responsible.
What do you say?
So do you have a vehicle?
No, I did not. I actually lost it in a car crash.
That's your problem, right? It's your responsibility to get there. And you're doing a GED in jail right now?
Yes, I am.
So like, why did you do a GED when you were not in jail?
I was actually attending to it, but there was a 6 months program and it wasn't.
Let me ask you this. Did you sign up for a GED program when you were out of custody?
I was trying to, yes. Ma'am.
So the answer to that is no. Okay. Why?
There was a 6 months waiting program, and between that, my probation officer wasn't letting me attend to it. She wanted me to attend right on the dot, basically, like on time when my probation was about to be due. And I kept on telling her the time is not gonna add up. So I tried actually even going, I tried to attend a different GED class, but they wouldn't let me because I had already did it 3 times.
Okay.
Is there anything else? Why do you think you should be continued and not be sent to prison? Why this time? Whose fault is it that you're here?
Take full responsibility over it.
All right, any questions?
Mr. Carvajal, you realize you're not in charge of the timeline here, correct?
Sure.
And you realize that the court determines your conditions of probation, correct? And you fail to comply with those, right? So why should the court believe this time as you're trying to take accountability that is different than any other?
I'm sorry, you have to answer the question.
Feel like I'll do better now this time, even though I know that I have messed up previously.
All right, the court is going to grant the motion, find you guilty. The court will hear arguments on time. And I know you're saying you want 6 months, counsel,
Yeah, ma'am.
and state you're asking for 2?
Yes.
All right. All right, the court is, as previously stated, the court is going to revoke, find you guilty, and the court will sentence you. And I'm going to give you credit for things that you have done. The court will sentence you to 13 months in the state jail facility, give you credit for any time served. Court will request the therapeutic community. And there is to be no contact with Hitzel, Hitzel, and JAR, JAIR, or ORTIZ. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand? All right, and counsel, do you think he needs therapeutic community or something while he's there?
I think there's some cognitive issues, Judge,
Mhm.
if we can get that addressed.
Okay. I will, with the therapeutic community, you're going to have to sign up for it. It's going to be placed in the judgment, and then you'll have to sign up to it as well.
That's good.
All right.
You need to get that.
Okay. All right. Thank you.
Thank
Good luck to you. Okay.
Yes, ma'am.
So